Hello, everyone. Okay, I'm taking my mask off. You can take yours off too if you're at home, distancing safely. I want to welcome you to today's webinar on trust planning. This is one in a series of webinars that we've done at our firm, Pierro, Connor & Strauss, and we've been trying to bring to you, while you're home, information that allows you to not only learn, but act on the learning and to get planning done. We're going to talk about how that's happening and all of the logistics and the technical aspects of getting a plan done from your own living room, which now, due to certain changes in the law, can be done. So this is our firm. We have 9 attorneys presently. We have 5 attorneys here in the Albany office, 4 in the New York City office, and our New York City office is expanding. But our firm is focused on estate planning, elder law, business succession planning, special needs planning, state trust litigation, guardianship, and we're here for you. And we're going to be talking about a number of the things that we do. Each of our attorneys has a little different focus, but we all work in what we call the private client area, dealing with clients who have individual, personal, and small business needs. So today's program is going to cover how we're planning in the COVID-19 era. It has changed everything, as you know. We are in a very, very different world. We are distancing. We are hoping we can get through it and keep that curve going down, as our governor says. And so far, we're making progress. Our office is open. We are working 75% virtually, 25% in office, and we have the capacity to meet with you, as we're going to see, virtually, like we are today, but also we can do appointments in office if that is necessary. We're going to cover today trust planning. We're going to just focus on 2 different basic types of trust. Before we get there, we're going to cover the core 4: a will, power of attorney, healthcare proxy, disposition of remains appointment. We'll talk about who the parties are to a trust, what a trust is, how it works from a legal perspective, why you use trusts for asset protection, probate avoidance, security, and long-term success of your family to protect family wealth, and what would be your next steps if you either want to implement a trust or perhaps modify a trust that you already have in existence. So with the new executive orders that Governor Cuomo signed, we're able to do everything with regard to a document that we would ordinarily do in person, from the initial consultation all the way through to the review of your documents, to the signing of your documents, notarization and witnessing. And all of that can be done in a secure virtual environment. There are logistics, and there is a memo that we've prepared explaining what each step is in the document creation and execution process. And that memo is part of today's materials, which you can access through the program. So, the core 4. This is something that everyone should have, and we start at very young ages for things like healthcare proxies and powers of attorney for children going to college, because if they do have a health illness or have a financial need where they need someone back home to take care of financial affairs, the power of attorney and the healthcare proxy become part of their planning at 18. You have to be 18 to do it. For someone who's looking to do estate planning, for whatever the reason, having a will with an executor and a beneficiary or beneficiaries, having a power of attorney, appointing a financial decision maker, a healthcare proxy, appointing a healthcare decision maker, and in New York, we have a document called the disposition of remains appointment, so that upon your death, you can actually appoint someone, an agent, to make sure that all of your final wishes are carried out, and you can spell out those final wishes in that document. So the core 4 is our basis. And we did a webinar on the basic estate planning, going through each of those 4 documents in great detail, which you can access along with all of our library on estate planning on our website. So you can go to pierrolaw.com, and we have a page there that has our online education courses, and this will be added to that when today is done. So if you have any friends that want to see this program, or you want to go back and review the core 4, that's the place to do it. You can do it right on the Pierro Law website. A will, as most people know, is something where you dispose of your assets, appoint an executor. What many people don't know is that a will doesn't have any effect. When you sign that will, you think, oh, I've done a legal document. It's effective. I appointed an executor. My executor can simply take my will, go to a bank, and upon my death, they'll be able to do things on my behalf. But that isn't how a will works. A will, by definition, has to go through the probate process. Probate is the proving of the will. And what that means is that you have to hire a law firm, petition a court, and go through a series of legal steps, including serving process on individuals, getting waivers from individuals, getting affidavits from the witnesses to the will, filing all that with the surrogate's court judge in your county, and then that will would be reviewed and a determination made as to its validity. Once the judge determines your will to be valid, they issue to your executor a piece of paper called a certificate of letters testamentary. Until that time, the executor has no authority to act on your behalf. Probate courts right now are primarily closed. So we're expecting a very significant backlog in probate proceedings. It's usually 1 to 2 years in any event to get an estate through the probate process. It has costs and delays that can really exacerbate that time frame and the costs and fees that are generated by a probate proceeding. It's a public process, and it's something that you generally don't want to have your family in court if you can avoid it. So how do you avoid it? And the avoiding of probate is done in a number of ways, but the most secure way and the best way to avoid probate is to use a living trust. So we compare and contrast the will to the trust, which is a private document, does not have to go through court. It avoids not only the probate court, but also the potential need for guardianship if you have an incapacitating illness or injury and you cannot manage your financial affairs. A living trust will give you the opportunity to manage during your lifetime, to have assets managed and used for your behalf, also for your spouse, for your children, anyone dependent on you, and upon your death, to avoid the entire court process of probate and to have a private administration of your estate, which is expedient and economical. So living trusts offer a number of advantages versus what we refer to as a testamentary trust. There are many different varieties of trust. The living trust is one you create now and transfer assets in generally. A testamentary trust can be created right through your will. But again, all of that depends on the probate process, and nothing happens in your testamentary trust until the will clears probate and you get a certificate of letters testamentary for the executor to collect the assets and a certificate of letters of trusteeship to have your trustee appointed to manage the assets. You can create all of those things through a living trust as an alternative for a variety of purposes. Simply that, to avoid probate and manage assets during my lifetime. That's a revocable living trust. When we move to irrevocable trusts, we do it for asset protection purposes, for tax purposes, and for a variety of other purposes to make sure that we are maximizing the value of our assets and protecting the beneficiaries that we have long term. So let's start with a revocable living trust. Generally, in this trust, you serve as your own initial trustee. So you don't need anyone else at the start of a revocable living trust. And the parties to a trust, as we're going to see on the next slide, are the grantor. So the grantor is the person who transfers assets into the trust. It's their property that funds the trust, and they hand it off to a trustee. So if I'm doing a revocable living trust, and I have my grantor hat on over here, and I have my assets, I put them in a revocable living trust, well, I just put my trustee hat on over here, and I'm wearing both hats. In addition, the beneficiary, the third party to the contract, is me and my family. So I'm actually wearing all three hats in a revocable living trust setting. So if I'm wearing all three hats and I'm putting my assets in and I'm managing my own assets and I'm the beneficiary, where does the value of that trust come in? And it really comes in one of two places. Upon incapacity, if you become disabled, incapacitated, you choose who is my successor, who is going to step in my place, manage my trust. All my assets are already in that trust, manage it for me, and look after my interests. So choosing an alternate trustee to yourself is critical in all trusts, but especially in a revocable living trust, because you're managing at first. You need somebody to step in behind you. The second time that the trust brings value is upon your death, because again, it avoids probate, all the delays, costs of probate, and you can take care of your beneficiaries in a living trust very economically and efficiently. So those are when the living trust brings you value. One critical thing to remember, because this trust is revocable, you can break it at any time. You can amend it at any time. Consequently, we're going to talk in a bit about an irrevocable trust for Medicaid planning purposes. In a revocable trust, it does not shelter your assets for Medicaid. We have an irrevocable trust we'll mention, as I mentioned, we'll go through a bit later in the program. So those are advantages of the revocable trust. It's far superior to a will. It creates a very good situation for your heirs and for your trustees down the line, your successors, gives them all the authority they need, and you can maintain control of your assets during periods of incapacity and upon your death through that revocable living trust. It's critical, as you see in the diagram, all assets except retirement plan assets, generally we recommend go into the trust. There's no reason not to, because you're in control 100%, and then they will clearly avoid probate. But what about assets like IRAs? Don't forget that when you do a plan, whether it's a will or a trust, you need to review all of your beneficiary designations for retirement accounts, life insurance policies, annuities, anything that you own that has a designated beneficiary. That beneficiary needs to be coordinated with your overall plan. And in many cases, we make the revocable trust the beneficiary of those assets, so that upon death, everything flows together for the benefit of your heirs. And so check on those. A lot of clients come in, I can't tell you how many, almost probably a majority of people, when we ask the question, who's the beneficiary of your 401k? Oh, I set that up 30 years ago when I started working. I don't remember. Don't be embarrassed. Don't be afraid. This is a learning process, but you need to have good data to make the plan work. This is a key element. Make sure that you coordinate all of your beneficiaries with your trust plan. What about those next generations? I have 3 children. I talk about them when we give live seminars. Why not talk about them on a webinar? My children are great. My son will be graduating college, my youngest, next Sunday, this coming Sunday, from Syracuse University. The other 2 are gainfully employed. My youngest has a job lined up when in August, when he graduates. And so when I leave assets, if I've worked my lifetime, how do I want to leave it to them? And if I'm in their shoes, how would I want to inherit it? Number one, I want them to be in control. They're all very bright kids and they can control their own assets. So I want them to be in control of the trust that I'm going to leave them. I want them to have access to it and be able to use it. But I don't want creditors to be able to penetrate the trust I create for my kids. I want divorcing spouses to be shut out. I want bankruptcy creditors to be shut out. Anybody that tries to sue them to be shut out. I want to create a fortress for my children that they can control and use assets from, and not have the ability for any creditors and divorcing spouses to get in. As a parent, if you're a parent, you know that's one of the big fears. I've worked a lifetime. How do I leave my assets to my children? We call it a beneficiary controlled trust. And when you have a revocable trust, I have 3 kids, my trust will last, let's say, for my lifetime, my wife's lifetime, then it will simply divide in thirds. Each of my children takes their own trust. The assets get divided. They manage it, they control it, they use it, but it is in a wrapper, that trust wrapper, that guards it for them and prevents it from being a target for some greedy divorce lawyer or ne'er-do-well outlaw that's going out of the family. You don't want that liability to be an open liability for your kids. And you can fix that by putting it in trust. This is a trust you cannot create for yourself. The key here is you are the grantor. They're your assets. They're not your children's assets yet. So before they get into their hands, you put them in the trust. Once they get into the children's hands, this trust is no longer available to them. So it's something that you have to build in. So we put it right into our revocable living trust or an irrevocable living trust, but protecting the beneficiaries is really a key. What if one of our children has special needs? We do a tremendous amount of work with the special needs population. And one of the things we have now going on is we have special needs children who are in their 60s and parents who are in their 80s taking care of them. That's a growing phenomenon. It could be that you have a child with a disability. It could be that you have another family member with a disability. It's possible for you to create a trust for that person that allows them to stay on the benefits that are so vital to them, Medicaid and SSI, supplemental security income, and still have that trust be managed for their benefit, have the income and principal be usable for their benefit, and have those government benefits still be there to pay for the primary health care and to give them some income to live on through SSI. So special needs trusts or supplemental needs trusts, they're the same thing. It's only a semantic difference. And you can do it creating it for your children the same way you do the BCT. This has a few wrinkles to it, but special needs trusts are excellent planning tools for children with disability. Okay, so Beth, how are we doing on time?
13 minutes to go.
13 minutes to go. So we're going to transition now from the revocable trust to one of the forms of irrevocable trust. And this is to gain that asset protection that I had mentioned earlier. When we look at how to pay for things like nursing homes, home health care, anything that you would need from a health perspective or a long-term care perspective, a lot of people rely on Medicare or think that they can rely on Medicare to solve this problem. Medicare does not pay for long-term care. Probably the most dramatic example of that is we work with a lot of clients who go on hospice. We help them prepare, we help them legally put their family in a position where they're going to be protected. And they get hospice and they think they're going to get a whole boatload of care. Hospice is a wonderful program. I highly recommend it for anyone who has a family member or going through a terminal illness. It provides tremendous services, but what it does not provide is day-to-day, hands-on home health aides. The only thing that does pay for home health aides is Medicaid. And so when we look at the spectrum of services and you look at, as I get older, will I need long-term care? Will I be in that 70% that's going to need long-term care if I'm 65 years old? If you are, and if you do need long-term care, the costs of long-term care now, nursing home costs are $160,000 to $170,000 per year. That's not the highest of the highs. The average is probably about $150,000 to $160,000. So how long can you pay for that? And what if I want to stay at home? Nursing homes right now are going through a real tough time. And I really feel for those frontline workers in nursing homes who are trying to deal with this COVID crisis in a very, very difficult setting. If you want to stay at home or want to keep your loved one at home, Medicaid is a program that will provide services in the home. But Medicaid is undergoing cuts. We did a webinar just a few short weeks ago. That's again on our website. 60 minutes on the Medicaid changes to home care that are coming into play on October 1st. Very critical time. But Medicaid does have home care services. We think that people should be looking to insure the risk whenever possible. Private long-term care insurance or life insurance with some type of a rider that will give you cash to pay for long-term care. If you can afford $150,000, $200,000 a year to pay for long-term care costs, then we say that you're self-insured. You've got enough income that your assets won't deplete but most people aren't in that boat. We're in a very different boat, much smaller boat, not a yacht. And for those of us in the smaller boat, we then have to look at either private insurance or Medicaid. The difficult part here is by the time you start thinking about this need, you're likely not insurable, or you're too old to buy the insurance because there is an age limitation, usually 80 years old, or you need long-term care and you have some pre-existing condition, you can't get it. So what do we do in that case when we have Medicaid as the option and we have a 5-year look-back period for nursing home Medicaid and a new 2.5-year look-back period for home health care? How do you get out in front of this and plan far enough in advance that you have the ability to access Medicaid if and when that need arises? And here comes our Medicaid Asset Protection Trust to the rescue. This trust has been tried and true since 1993, came into the law at that point. We have been using a trust similar to the one we have now for that entire time period. It's evolved and advanced based upon more modern drafting techniques, but the core principles of a Medicaid Asset Protection Trust have been with us for a very long time, and it works. And so getting out in front of it and getting a trust in place, again, you are the grantor, and you're going to take your assets, put them into this contract called a trust agreement, and you're going to hire someone for free, most cases. You don't pay them, but you appoint them as trustee of your trust. We generally recommend in this case, unlike the revocable, that you don't act as your own trustee of the Medicaid Asset Protection Trust. So you're going to have mostly children, but it could be anyone, and they're going to manage the trust for you. Your assets go in, you keep the income. So the dividends and interest flowing off the assets stay yours. The principal of the trust is in the trust document and cannot come back to you directly. So the beneficiaries of the income are you. Ultimately, the beneficiaries of the principal, what's left in the trust, are going to be whoever your heirs are, your children, nieces, nephews, whoever that might be. And at the end of the trust, they're going to receive it with tax benefits, including a fully stepped up basis for the assets in the trust. So what goes in? Your home. We deed the home into the trust, and in many cases, the home is the only asset. So we use the trust to protect the home for Medicaid purposes. Bank accounts, stocks, bonds, life insurance, business interests, real estate, they go in, income comes back to you. Remember I said principal can't come to you, but it can go back out to the children. So the income going to the kids, or excuse me, the principal going to the kids, once they receive it, there is no string on it. They can do with it whatever they please. What would you like them to do with it? In most cases, you want the principal coming out if you have need. Let's say that you want to buy a new car and you want to get $30,000 out of your trust. Your trustee can hand it to your children, and we have certain ways that we do that, who could then turn around and buy you the car. There's no restriction on what they do. Well, what if they go rogue? What if my trustee goes rogue? What if my beneficiaries go rogue? You have the power. In the trust document, we give you the power to fire the trustee at any time. Wouldn't you like to say that? You're fired. And you can also change the beneficiaries. So at any point in time, you can flip the trustees, you can remove beneficiaries, you can replace beneficiaries. And because you control who those beneficiaries are, under a very little used provision of New York law, it's called the States Powers and Trusts Law 7-1.9, you can actually revoke the trust, even though it's irrevocable, provided you get the consent of those beneficiaries. So it is a flexible arrangement. It protects your assets, and it is the way that we design a plan. If you don't have that $200,000 a year of cash flow that you need to pay whatever long-term care expenses are, then having Medicaid as a backup is the way to go. What about tax planning? I mentioned that irrevocable trusts are used for asset protection. They're also used for tax planning. What do you have to worry about if you want to worry about estate taxes? Well, right now, if you have an estate over $11,580,000, then you have a federal estate tax problem. If you're under that, then you probably don't have a federal estate tax problem, but you may have a New York problem. There's a gift tax exemption equal to that, and it's also $11,580,000 if you want to give assets away. Everybody got their checkbook, you're at home, pull out the checkbook, and let's all write a check for $11,580,000. That's tax-free gift. That's your lifetime exemption. You see the $15,000? A lot of people confuse these. Some people think it's still 10. In addition to $11,580, you can give away $15,000 per person per year. That's called the annual exclusion. So most of us don't have to worry about federal estate tax planning. Those that do, there are tremendous opportunities right now to shift wealth. And if that's a situation that you're in, we certainly want to talk to you about a plan that can preserve those assets and in many cases eliminate that estate tax. In New York, the number is $5,850,000. So $5,850,000 for New York estate tax exemption. If you're a married couple, you're going to do trusts and you're going to do tax planning. So you can actually double that with sound planning in your trust document. And in New York, we have no gift tax. So again, tremendous opportunities to gift assets under New York law, and provided you live 3 years, there's a 3-year clawback, they call it, and provided you live 3 years, those assets are outside of your estate. Now, with the budget changes, with the deficit and the debt that's going to be anticipated as a result of the coronavirus and the changes in our economy, these tax laws are going to change. They're going to change rapidly, not for the better. So the sooner you get the tax planning done, the better you're going to be getting it done under current law and taking advantage of current exemptions. I just want to point out one other legal change that happened on January 1st. It was a big deal until the pandemic hit, and now it's kind of gotten brushed to the side. But if you have an IRA, 401k retirement plan, you used to be able to leave it to an individual beneficiary and they could stretch it over their lifetime. No longer the case. Now that individual beneficiary has to take it out over 10 years. So it's going to force it out and they're going to have to pay the income tax on that qualified retirement account over a 10-year period, unless there's someone who is a spouse, a person with a disability, person with a chronic illness, and trust planning for your retirement benefits is now just as important as it was before. And we do specialized trusts to receive inheritances of IRAs and 401ks to make sure that we maximize the value of that income tax stretch. You can still have the stretch if your beneficiaries fall into any one of those categories. So some people come with trusts that they've already done. Some come looking for a trust. Can you modify or change a trust that's irrevocable? And the answer is yes. I talked about one way to do it under that statute, and there it is, EPTL 7-1.9. But you can always, in our trust, if it's a Medicaid trust, change trustees and beneficiaries. There is in New York a decanting statute where you can actually create a new trust and pour the assets over. And at the end of the day, if we can't do it any other way, we do a judicial modification. We go to court and ask that it be modified. But there are ways, even when the trust is irrevocable, that it may be able to be modified or changed to meet your needs. So what are your next steps? Following this webinar, you're going to get a survey, and we would be very, very happy if you would fill that survey out for us. It'd be very helpful to us. We are planning future programs for future webinars. We're going to talk about that. Our next one is on June 9th, which is going to, again, revisit the Medicaid home care. And before you join us on June 9th, you may want to go to our website. It's right on our homepage and watch the 60-minute video on the Medicaid changes coming in October. June 9th at 11, and then June 17th, we have our trust administration workshop, 6 to 8 p.m. We're hoping to be live. If not, then we'll be transferring that to a virtual format. As always, we have guides on a variety of topics. You'll see them on the screen there. We have our video library that also covers a lot of these topics. And we are conducting on a regular basis webinars for professionals, giving professional education. We have our annual Elder Law Forum, our 25th annual coming up. That will this year be done all virtually. And if you're a professional out there and you want to get onto the Elder Law Forum list, just email us, as always, at info@pierrolaw.com. We hope you listen every Saturday morning at 11 o'clock to Talk Radio WGY 810 AM 103.1 FM for our Life Happens radio show, which we enjoy bringing to you and try to bring you current and valuable information to help you plan. And at this point, I think we're through our 30 minutes. Thank you for joining us today. We're very happy that you could. Hopefully you're ready for lunch. Should be coming up soon. And if we have any questions, Beth gave you the instructions earlier on how to post them, and she's waiting to read them to me if anyone has a question on anything that was presented.
Lou, we do have a question. How long does it take to create a trust start to finish?
When do you want it? You know, we are able to do trusts. We literally have done a trust in a matter of hours. Someone who was an extremist, someone who had to get the planning done, we can move it in a very, very rapid fashion. The typical scenario is once we have our consultation, you will get a questionnaire that we ask that you complete for us that will give us the information that we need, both names of the individuals who are key in your plan as fiduciaries and beneficiaries, their contact information, your asset information, and we will walk through all of that with you at an initial consultation. The draft of that document, or documents rather, that come from that consultation are generally going to come to you in 7 to 10 days. You will then have an opportunity to review it. We now can do a video review, so we'll schedule a document review meeting where you'll have documents, we'll have documents, we'll walk through each provision with you. Once that's done, we're ready to sign. Once you've made your final edits. So we would set up another video consultation. And again, the memo that's part of your materials lays out what the process is. But we're doing them 8 to 10 a week right now. So we can schedule you for next day, next week, get the documents to you and have the documents signed. So it can be as little as 2 weeks. It could be longer, depending upon really how long you need to process, how long you need to digest the information. What you don't have to have is all of your asset information prior to signing the trust. Once the trust is signed, then the trust funding begins. That is going to be another process. Transferring assets, we'll prepare deeds to real estate. If you have businesses, LLC interests, stock certificates, all of those things get transferred into the trust, and that's the funding process, changing beneficiaries on your IRAs and your insurance policies. All of that follows the document execution. So generally, to get start to finish in our current model, it's actually faster than when we were meeting in person. It can be done in, I would say, 30 days.
All right, well, we're all set, and further questions can be emailed to us at info@pierrolaw.com. Thanks, Lou, for an informative presentation, and thanks to you for watching. This concludes our webinar. From all of us at Pierro, Connor, and Strauss, please be well
and be safe out there.
Thank you.